In this segment, I want to continue discussing the theory of selective incorporation, specifically as it bears on the issue of free speech, free press, and freedom of peaceable assembly. How does this work? Prior to the passage of the 14th Amendment, a citizen had their free speech or free press or free assembly protected against actions of the federal government, but not against actions of the state. It was the 14th Amendment which made all persons born in the United States or naturalized in the United States citizens of the United States and of the state in which they resided. It is that portion that began to protect citizens against actions of their states. The theory there is that freedom of speech is such a basic right that to deny a person free speech by an act of the government would be to deny that citizen due process of law. If it was a newspaper, freedom of the press, that newspaper would be protected by actions from the state or any of the state subunits like cities or counties because their due process rights would have been denied. And if it was a case of assembly, similarly, if there was going to be a peaceable assembly, the federal government couldn't deny a peaceable assembly. But now, as a result of the 14th Amendment, neither could any of the states, cities, or counties. This is the notion of incorporation. Except, it's not total incorporation. Because as the courts have looked at the Bill of Rights, they found that the Bill of Rights was very important, but not every right stated there was equally important. Some were a critical part of due process, but others were not. And so it took time for the court to decide to protect speech, press, and assembly. The first right that was protected under the doctrine of selective incorporation was a right to protect property, and it was a right granted to corporations, not actually initially to citizens. In 1896, some of the states sought to pass laws setting rates for railroads. They did so because they thought the railroads, which had a monopoly in most areas they served, that they were not serving them well and were charging exorbitant rates to small individual users while giving big breaks to corporations. So states like Illinois and Minnesota and some others sought to pass laws setting rates for railroads. The railroads, wealthy as they were, had able counsel, and they appealed all the way to the Supreme Court. And the Supreme Court in 1896, the late 1890s anyway, discovered that the railroads were protected by the 14th Amendment, that their due process rights to life, liberty, and property were damaged if a state could act against them. That was the beginning of selective incorporation. Now, of course, in the 21st century, having a history of the entire 20th century, this right granted to the corporations seems strange indeed. But that merely is a side issue compared to the issue of free speech. The initial case of free speech involving the states is Gitlow versus the United States. Gitlow versus the state of New York, I'm sorry. Gitlow had acted in a way that went contrary to the laws of the state of New York. He was charged with a violation of free speech under New York law. He appealed to the U.S. Supreme Court and raised the claim that his right to free speech should be protected by the Bill of Rights. And the Supreme Court agreed. They agreed that Gitlow's right to free speech was protected by the First Amendment of the Constitution, because First Amendment free speech rights were a critical part of due process, and Gitlow was protected. Unfortunately, they then decided that Gitlow, his act of free speech was not protected, that that his notion of free speech was excessive, and that wasn't protected. Not a very auspicious beginning, but the critical point was that his right to free speech was now not against the federal government, but was against the state of New York and any of the subdivisions of the state of New York, because of the doctrine of selective incorporation, because as he was protected not just as a citizen of the United States, but as a state of New York, and New York was now required to grant him due process, just as the United States government would have granted him due process. Free speech was now part of the rights that were incorporated. The next major right that was incorporated was in a separate action of selective incorporation. That was the action of free speech, and in this case it was the state of Minnesota that caused the action. In that case, a man named Neer operated a small mimeographed paper. You couldn't really call it a newspaper in the full proper sense. It was a kind of like a mimeographed handout. Mr. Neer had issues with the city council in Minneapolis and St. Paul, the so-called Twin Cities. He decided that those governments were corrupt. He decided they were run by gangsters. And indeed, a pretty good case could be made that corruption was widespread in those city governments. But Mr. Neer didn't attack the corruption alone. He attacked the individuals on grounds that they were Jewish. Neer was an anti-Semite. The state of Minnesota reacted harshly to Mr. Neer. They decided that Mr. Neer had engaged in sedition against the state of Minnesota, and they shut down his newspaper. Mr. Neer sought to protect himself, except Mr. Neer didn't have any money. He just ran a little mimeographed handout. But the case caught the attention of someone else named Robert McCormick, Colonel Robert McCormick, he was often called, and he did have some money because he happened to be the publisher of the Chicago Tribune. McCormick intervened on behalf of Neer because he saw, in the case of Neer versus Minnesota, a threat to his own business. What if the state of Illinois passed a sedition act and sought to shut down his newspaper? Neer, with McCormick's background, appealed the case to the U.S. Supreme Court, and at that time, the U.S. Supreme Court decided two things. Yes, Mr. Neer's right to run a newspaper was protected by the First Amendment, and that protection was granted not just by the United States, but by the state of Minnesota, because Neer's right and McCormick's right were protected by the first section of the 14th Amendment. Selective incorporation had now been applied to press. And on top of that, in Neer's case, they decided that shutting down his newspaper was a prior restraint, and that prior restraint violated or constituted an abridgment of freedom of the press. So now, after the end of Neer versus Minnesota, one could read the First Amendment as follows. Congress shall make no law abridging freedom of speech or of the press. And also, Congress shall make neither Congress nor any state legislature nor any subunit of any of the states could pass a law abridging freedom of speech or of the press. Now, both the federal government and the state governments were banned from affecting speech or press. The third step in the process of selective incorporation came in a couple of cases, perhaps the most famous of which is Hague versus CIO. It was a labor law. Labor unions that were a part of the CIO sought to demonstrate. They sought to march up and down the streets with placards. the states sought to limit this, especially those states that were influenced by big business better than big labor. The CIO appealed their case to the Supreme Court, and it claimed that they were engaged in a peaceable assembly and that they should be protected by the First Amendment, since their rights, in whatever state they were in, were also incorporated. And the Supreme Court agreed. The Supreme Court agreed now to speech, press, and assembly. Those three rights were now incorporated. Individuals' rights to speech, press, and assembly were now protected, not only against the federal government, but against the state governments and any of the state subunits. Selective incorporation had now been applied across the board. Now, I'm only going to be able to deal with speech, press, and assembly in this course, but a whole range of other rights. The rights to be protected against unreasonable searches and seizures, the rights to be protected against cruel and unusual punishment, the rights to no excessive bail, the right to a jury trial, the right to no double jeopardy. All of a whole range of rights in the Bill of Rights have now been selectively incorporated, and they now apply not just against the federal government, but against state and local governments as well. It's important to look at this history in order to understand how it is that we have come to have the existing rights of speech, press, and assembly, which I'll take up in the next lecture. Okay, Billy.